In this video, we will be discussing about Section 185 of the Companies Act, which provides for the loan by a company to its directors. Now, this section is a restrictive section and it restricts certain transactions by a company with its directors. Let us first understand who all are considered as director for this particular section. That is, this restriction is applicable on the directors of the company, the directors of the holding company, any partner or relative of such director, or any firm in which such director or relative is a partner. Now let us understand it a little better. Who are the persons who have been restricted to take loan from the company? First, if there is a company A Limited, then his director, the relative of such director, a firm of such director, or his relative. And if the director is a partner in any firm, then the partner of such firm as well. Similarly, if there is a holding company of A Limited, then A Limited cannot advance loan to the director of such holding company, the relative of such director, the firm of such director or his relative, and if such director is also a partner in some other firm, then the partner of such firms are also restricted. Now, the question is whether the director of subsidiary company can take loan from company A Limited. Since this section does not restrict him from taking loan from the company, yes, A Limited company can advance loan to the director of subsidiary company. Now that we have understood who are the persons which have been restricted under section 185, we should further understand the transactions which have been particularly restricted under this section. So any transaction which is direct with the director or indirectly through its relative, firm or partner are prohibited under this section. Such transactions are advancing of any loan to the director, including loans which are represented through book debts. So if the company has given any loan to the director or his relative or his firm or his partner, it should be prohibited. It should also include the book debts. Now, what are the book debts? If we go with the dictionary meaning, it says any money that the company has not yet received from its customers who owe it money and which is recorded in the company's accounts. So this basically means if the company has given any goods or services to its directors or relative or firm or a partner on advance or credit which is yet to be received from them and which is recorded in the company's accounts as book debts, such book debts will also be considered as loan to director. Let us take few examples. If any director of company A Limited has purchased certain goods from A Limited on advance and the company has recorded such advance as book debts in its accounts, such book debts shall be treated as loan to director and should be prohibited. Another example would be if the director of A Limited has a partnership firm B Associates and such firm has taken certain services from A Limited. Now this will also be considered as book debts if taken on advance or on credit, and same shall be prohibited. Another example could be if director of A Limited's holding company has a brother who has taken certain goods and services from A Limited on credit, such amount shall also be treated as book debt in the company's accounts and it shall be prohibited on account of loan to director. So going back to the transactions which are restricted, the other transaction which is restricted is giving of guarantee given against any loan. So if the company has given guarantee against any loan taken by a director or his relative or firm or his partner, then such guarantee shall also be treated as loan to director and thus prohibited or restricted. The other transaction is providing of any security against the loan taken. So if the director has taken any loan or his relative has taken any loan and a company has provided security against such loan. It has mortgaged its asset, or in any other way the company has provided its security, then such security shall also be treated as restricted transaction and the company cannot move forward with such transaction. So this is all about the transactions which are restricted under this section. Now a very important aspect here is the definition of relative. Relative has been defined as any person who is related to another in the following manner. They are the members of Hindu undivided family, or they are husband and wife, or a person shall be deemed to be relative of another if they are related in any of the 8 manners, which is he is the father or the stepfather, mother or the stepmother, son or the stepson, son's wife, daughter and daughter's husband, brother including stepbrother, and sister including stepsister. So these 8 relatives of the director or holding company's directors would be considered as relative. And in addition to these 8 relatives, the husband or wife of the director, and if such director is a member of Hindu undivided family, then all the members of such Hindu undivided family would also be considered as relative for this section. Now, subsection 2 provides for certain conditional advancement of loan or book debts or guarantee or security. It further provides to whom such loan is allowed subject to certain conditions, which we will be discussing in the next slide. So who are these persons? These persons have been defined as any person in whom the director of the company is interested. Further, the section provides for the definition of such interested persons. The first person would be any private company in which such director is a director or member. So if any director of A Limited is a director in any other private limited company or a member of such private limited company, then A Limited can advance loan to such other private company. The second person defined as interested person is any body corporate at the general meeting of which not less than 25% of the total voting power may be exercised or controlled by any such director or by 2 or more such directors together. Now, what is 2 or more such directors? So, if company A Limited has 2 directors, X and Y. So, if X holds more than 25% of the shares of that company, or X and Y together holds more than 25% of the voting power, or maybe X and Y and any director of the holding company together holds more than 25% of the voting power, then the company A Limited can advance loan or book debts or guarantee or security to such body corporate. Similarly, any body corporate whose board of directors, managing director or manager are accustomed to act in accordance with the directions or instructions of the board or any of the director or directors of the lending company. So if there is any body corporate, the board of directors is which is accustomed to act upon the directions or instructions of the director or directors of A Limited will be considered as interested person, and loans or book debts or guarantee or security can be advanced by A Limited to such body corporate. Now let us move forward to the conditions subject to which loans or book debts or guarantee or security can be advanced to the interested person by a company. The conditions include passing of a special resolution in general meeting approving such loan or guarantee or security or book debt. The notice of the general meeting should have an explanatory statement as per section 102 of this act, wherein a proper disclosure is given with respect to the full particulars of the loan or guarantee which has to be given or the security that has to be provided, the purpose for which such loan is proposed to be utilized by the recipient, Also, the condition says that loan should be utilized by the borrowing company for its principal business activities only. So the loan cannot be taken by the borrowing company for any other purpose other than its principal business activity. Now, Section 185 subsection 3 provides for the loans which have not been restricted under this section. Thus, they do not cover under prohibited transactions by a company under section 185. Any loan which is given to the managing director or whole-time director of the company, provided it is given as a part of any condition of services extended by the company to its employees, or it has been given pursuant to any scheme approved by the members of the company by passing a special resolution. Then, if the ordinary course of business of the company is to provide loans, in such cases also the company can advance loans without any restrictions. But the interest on such loans should be charged at a rate which should not be less than 1 year, 3 year or 5 year or 10 years government security yield. Further, any loan which has been given by a holding company to its wholly owned subsidiary. Now, this loan also includes the guarantee or security against any loan extended to the wholly owned subsidiary, provided such loan is utilized by the subsidiary company for its principal business activity only. So, holding company can give loan to its wholly owned subsidiary subject to the condition that it uses only for its principal business activity and no other purpose should be there. Now, private limited companies and government companies have been exempted from the provisions of this section, provided they fulfill certain conditions which we will be discussing now. For private limited companies, there are 3 conditions, and all the 3 conditions should be fulfilled. The first condition is no body corporate should have invested any money in the share capital of such private limited company, which means the private limited company should not have any body corporate as its member. The second condition is the borrowings of such private company from banks or financial institutions should not be more than twice of its paid up share capital or 50 crore rupees, whichever is lower. And third condition is the company has not made any default in repayment of such borrowings which it already has at the time of making transactions under this section. So if the company has already taken borrowings previously, then it should not have defaulted in making its repayment. So if a private limited company satisfy all these 3 conditions, it can provide loan to its directors. Further, a government company can exempt itself from the provisions of this section by taking approval of the ministry or department of the central government which is administratively in charge of the company, or the state government, before making any loan or giving any guarantee or providing any security under this section. Now, what are the penal provisions under section 185 of the Companies Act? This has been provided in subsection 4 of the same section. The contravening company can be penalized with a fine which shall not be less than rupees 5 lakhs, but it can be extended up to an amount of rupees 25 lakhs. Every officer of the company who is in default can be penalized with an imprisonment of a period which can be extended up to 6 months, or a fine of rupees 5 lakhs which can be extended up to rupees 25 lakhs. The director or any other person to whom the loan, guarantee or security has been granted by the company should be imprisoned with a period which can be extended up to 6 months, or a fine of rupees 5 lakhs which can be extended up to 25 lakhs, or both imprisonment and fine. So this section penalizes all the 3 parties, that is the company which is granting the loan in contravention of the provisions of this section, every officer of the company who is involved in such default, and any person or director to whom the loan has been granted. Now let us take few examples to better understand the provisions of this section. Amit is a director in A Limited and his wife is a partner in Mehra Associates. Now, A Limited has provided security against the loan taken by Mehra Associates. A Limited has never taken any loan previously or it does not have any body corporate as its member. Is the security provided by A Limited to Mehra Associates allowed under the law? Yes, it is allowed. Why? Because the company is fulfilling the conditions provided for availing the exemptions under this law. It does not have any body corporate as its member, and also it has not taken any loan previously, so it has not made any default as well. And the provisions of this section should not be applied on this company for this particular transaction. Now moving forward to the second example, Amit is the director in two companies, A Private Limited and B Limited. A Private Limited has advanced a loan of rupees 5 lakhs to B Limited, and A Limited does not have any body corporate as its member or it has not taken any loan previously. So is this loan allowed under the law? Yes, this loan is allowed. Why? Because A Private Limited has fulfilled all the conditions for availing exemption under this section. Further, what are the compliance that should be proceeded with by A Private Limited for granting such loan? A Private Limited should pass a board resolution. That is, it needs to take the board approval by passing a board resolution before granting such loan. In a third example, Amit and Neeta are two directors of A Private Limited, which has granted loan to B Private Limited, where Amit and Neeta are holding 20% and 4% voting power respectively. Also, A Private Limited has another body corporate as its member. Now, since A Private Limited has another body corporate as its member, it cannot avail exemption under this section for granting of loan to directors. So now, will this loan be considered as a prohibited loan? If we go back to our definition of interested persons, it includes any private limited in which such director is a member or a director. So, such loan can be given subject to the fulfillment of conditions of subsection 2 of section 185, which requires passing of a special resolution in general meeting and disclosure of requisite information in explanatory statement attached to the notice of such general meeting. Now, fourth example is similar to third example, except for the borrowing company is a public company and both the directors are holding 24% of the voting power. Now, if we go back to the definition of interested person, the first definition says any private company in which such director is a director or a member. Our borrowing company is a public company, so this definition does not fit. The second definition says any body corporate at the general meeting of which not less than 25% of the total voting power is controlled by such director individually or together with other director. So in our example, both the directors are together holding only 24% of the voting power. So they will not be included in this definition of interested persons as well. So if we go back to our example, the fourth example cannot be treated as an exempted loan and it shall be prohibited under this section. This is all about section 185 of the Companies Act, which provides for the restrictions on the loan granted by a company to its directors, which includes guarantees, securities and book debts. It also provides for certain exemptions to private companies and government companies, fulfilling which loan can be provided by a company to its directors. Thank you for watching. You may send your queries to me at aditijain241@gmail.com.